as the European Union, we are at great pains to protect our citizens as consumers when they buy goods cross-border through Europe's internal markets. So when you buy a camera or some other good cross-border, or when you're on holiday, you have the full panoply of European consumer law behind you and protecting you. But when you make what may be the biggest or the second biggest investment of your life financially in buying a property, then to an extent you're on your own and you're facing a national legal system with which you are unfamiliar.
We need to have legitimate faith in the institutions and the rule of law. There needs to be a clear definition of coastline, which ensures that coast is simply along the coast. There needs to be more legal information provided. When people need to defend themselves against powerful administrations, the path can be long and costly, and this needs to be dealt with as well.
Without defending the property rights, there is no freedom. And I can recommend you one of the best books that I have ever read, which is written by a British writer, Richard Pipes, which is Property and Freedom.
I think we have, therefore, because this is where the petitions have come from, largely focused our efforts on the problems faced in Spain. We know the situation in Spain, we know its serious financial problems that it is going through, the enormous levels of unemployment which have resulted from precisely the property bubble that even in our reports we were talking about 3 or 4 years ago. And I think that now it really is urgent that, as Diana has referred to, some system of legal certainty is established for property owners and for property sellers in Spain.
We should realize that when you are buying a piece of land or when you're buying a house in another member state, you are not necessarily buying this from a professional party. Instead, you might very often actually be buying from another personal party, from another private party. And that means that this would be a C2C situation, so a consumer-to-consumer situation where all this beautiful consumer protection acquis would not necessarily apply. And you could, of course, say, well, you will deal with a real estate agent or other professionals, but those will usually be intermediaries. So the contract that you eventually conclude will be between two parties at the same level.
We do, however, then have to develop a European property law. And here again, we can learn quite a lot from contract law and tort law, where we have a whole gamma of directives, regulations, and so on, and then afterwards had to discover that they were incoherent, that they gave different levels of protection. Some were maximum harmonization, some minimum harmonization. Periods differed. That is what we are now trying to solve through the common frame of reference. We should avoid this whole set of problems. When we enter property law, we can learn from past experience. So do it right immediately.
Registers do give you a form of harmonizing property law, essentially. Because registers all work in the same way, it is much easier to harmonize registration systems than it is to harmonize property systems. When I say that registers work the same way, I am assuming that there is a battle for survival of the fittest, that ultimately the German system is the fittest, the English system is pretty close to the German system, and that the French and Latin system is less fit.
The question of retrospectivity. Some of the problems, it seems to me, that have been suffered in Spain are nothing to do with the existing law, or indeed with protecting citizens in advance when they enter into transactions. They're to do with the actions of governments and legislatures. If it's right that the Human Rights Convention does not provide an answer to that, then query whether the European Union conventions can provide an answer to that as well. They seek to take the same line, and the line that's been taken politically consistently is that governments, states are entitled to expropriate rights, but if they do, they must provide proper compensation.
In the view of the breakdown of legal certainty in international real estate transactions, European Land Registries assumes the responsibility to enhance confidence, becoming an effective instrument for the integration of the single market at the service of European citizens.
Another difficulty in relating to this issue relates to the professionals involved, their competences and their powers, because these can vary between member states. In Belgium, the notary is the main figure who authenticates property contracts, but we know that this system doesn't exist everywhere in Europe, and the role of a notary can vary considerably. We know, for example,
I would just say 2 words about what solutions to draw here for the future from our point of view. Well, I think listening to interventions this morning, there are fields of action where it seems difficult, at least in the short term, to do something, and that is, I would draw the conclusion about really substantive property law. There appears to be a consensus in the room. And also, I must say that I think that the problems explained this morning would not be solved by harmonization of substantive property law.